How do you protect how your product looks? Today, we're tackling the two-headed monster of design IP, design patents, and trade dress trademarks. This is where serious protection and some serious money is for innovators in product manufacturing and design. I'm Julie King of King Patent Law, and welcome to week 4 of this year's spooky season post. This week's topic covers an often neglected but important way of using intellectual property law to protect your business, which is protecting how your products look. Utility patents protect how a product works. Design IP protects how a product looks. You may need two different types of protection to fully keep your product safe from copycats: design patents and trade dress trademarks. Head 1 is the design patent. A design patent protects the ornamental appearance of an article of manufacture or functional object. It's for the aesthetics. Think of it as a blueprint for the eye. A design patent protects the specific shape, configuration, or surface ornamentation of a product. It's purely aesthetic, not functional. In fact, any reference to the function of the design won't be allowed. You can still protect the function with a utility patent under certain circumstances. Do you have a unique jewelry design? A distinctive sneaker silhouette? How about a stylish new vape pen shape? Those are all good candidates for design patents. There is power and advantage in a design patent. A design patent provides a 15-year, non-renewable monopoly on that specific look. It gives you exclusive rights for 15 years to prevent others from making, using, or selling a product that is substantially similar to your patented design in the United States. What's the key advantage? You can get things rolling with this protection early. You can start to secure this protection before you can protect anything using trade dress trademark rights, giving you a head start to sell your cool-looking product before anyone else can copy the visual design. Usually, design patents are issued within 2 years of the application date, but the protection will be retroactive to the application date, but only if you put patent pending on the product or on its promotional material that comes with it, because that gives people constructive notice that patent rights may be forthcoming. In contrast, it can take years before your design is eligible for trade dress trademark protection. Another advantage of a design patent is that while it's only for looks, it won't necessarily be rejected just because those looks also affect how the product functions. There are some drawbacks of design patents. Again, design patents cover only how the product looks, not anything about how it functions. If the design is essential to how the product functions, it won't qualify for a design patent. The design patent won't cover functional use at all, but unlike with trade dress trademarks, also being useful isn't necessarily a problem as long as the functionality isn't essential to how the product works. If there are a variety of other designs for the product that can achieve the same function, the design is probably suitable for a design patent. However, if there aren't any other possible design, the design is essentially functional and won't qualify for a design patent. Also, a design patent doesn't last all that long. After 15 years, ornamental design enters the public domain. That's why you need trade dress protection as well. Head number 2 is trade dress. A trade dress trademark is the most enduring brand protection for product aesthetics. Trade dress is a type of trademark that protects the overall visual impression of your product or packaging. It's part of the brand's persistent visual identity. Trade dress protects elements like a product's distinctive shape, size, color combination, texture, or even the layout of a retail store. Think of the distinctive look of a McDonald's or Apple store. The iconic, curvy shape of a Coca-Cola bottle is the textbook example of protected trade dress for product packaging. Competitors can sell cola in a straight glass bottle or a bottle of any other shape pretty much, but they cannot use that specific, non-functional shape because it has acquired distinctiveness, meaning consumers instantly know it means a Coca-Cola product. So what is the power and what are the advantages behind trade dress protection? If the trade dress successfully identifies the source of your goods to consumers, protection can last indefinitely, as long as you continue to use and defend the mark, and of course, pay the required maintenance fees to the USPTO if you registered it as a trademark. What are the drawbacks of trade dress? Note that I said non-functional when I mentioned the Coca-Cola bottle shape. That's the key. It can't have anything to do with how the product functions, and you can't market it as making the product more useful. That's more restrictive than a design patent, which again also covers only how something looks, but isn't precluded necessarily by the looks also being functional, as long as that functionality isn't essential to how the product works. That means if you have a utility patent that covers part of the design, it won't qualify for trade dress protection. Trade dress must also be inherently distinctive. That means it must be how the public knows the product or service is from a particular business. Think about how if there were no other branding clues like names or logos, you know you were in a Waffle House, and I'm not talking clientele. Or that the packaging meant there are beauty products from Sephora inside. That means it has to be in use in commerce. That means on sale, being used in marketing, etc. You can't just intend to have trade dress trademarks. That inherent distinctiveness can't happen before it's in front of the public. It's developed over time through use with the public. It is called secondary meaning because it means more to the public than just a nice design. It has become as much of a brand identifier as a name or a logo. Now, this requirement is different from how names, logos, slogans, and other types of trademarks work. As they say, two heads are better than one. Here's why you need both of these tools and how these two heads of the IP design protection work together nicely as a ferocious beast. The timing. First, when you launch your product, you can file a design patent application immediately. Once it's approved, which can take a little while, but is retroactive to the application filing date, the patent gives you the next 15 years if you need it to fend off direct copiers while you build your brand. During those 15 years, you heavily advertise and market your unique design. You are building that secondary meaning necessary for the inherent distinctiveness for a trade dress trademark. When the patent expires, your protection doesn't end because your trade dress trademark lives on, protecting the unique look of your product as long as you use it. It's a two-stage defense that ensures your investment in a unique look pays off for decades. Don't let your unique designs become an early casualty. Protect your look, and your brand can live on. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand, you need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. I'm an attorney in Champaign-Urbana, Illinois, and I serve intellectual property clients nationwide. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe if you haven't already. You can find all of my other frighteningly good content on the King Patent Law website, at Know Your Rights, Your IP and Business Law Playbook on all major podcast platforms, and at King Patent Law on most social media. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here without first seeking the counsel of a licensed attorney, perhaps me, for your specific legal needs.